Milwaukee, Wisconsin. A Thursday morning in November of 2025. Linda is 53, licensed practical nurse. 28 years watching families navigate the medical system. She knows how paperwork works. She thought she knew how this worked. She is standing in the kitchen of the house she grew up in, her mother Helen's house. Helen, 79, retired librarian, paid off the mortgage in 2011, $342,000. The same lace curtains, the same kitchen where Linda's children called it Grandma's house and meant it like a compass point. Helen died 6 weeks ago. Memory care in Brookfield. The last 14 months, Medicaid paid. The social worker said the house was safe. Linda is holding a certified letter from the Wisconsin Department of Health Services. The state is filing a claim against Helen's estate. Amount, $289,417. Linda sets the letter on the Formica countertop, the one where Helen taught her to make pierogi, and reads it again. As if the number might change, it doesn't change. You believe the house is safe. Every social worker, every nursing home admissions coordinator, every hospital discharge planner in America delivers the same sentence to the same panicked family in the same beige conference room. Don't worry. As long as she has the intent to return home, the house is exempt from Medicaid. The house is safe. And it is true, while your parent is alive. Medicaid cannot force the sale of an occupied or intended to be occupied home while the recipient is living. The sentence they never finish. The protection ends the moment the person dies. The day Helen passed away, the house stopped being exempt. It became a recoverable asset. And the state had been waiting patiently, legally, with automated systems that monitor probate court dockets for exactly that moment. Here's what actually happens. The house goes through probate, the state files a claim, and the family discovers that the house is safe was only ever half the sentence. Before I show you exactly how the probate ambush works, if your parent is on Medicaid right now, or ever has been, and you own or expect to inherit a paid-off home, hit the like button right now. Not because I want a number to go up, because that click tells YouTube to put this video in front of the next Linda before she's standing in that kitchen holding that letter. Subscribe and flip the bell, because next week I'm covering the widow's tax cliff, the bracket ambush that doubles the IRS bill in the surviving spouse's very first filing year. You'll want to already be here when that goes up. Now, meet Linda's mother Helen and meet Ronald. Helen was 79, retired librarian, paid off home in suburban Milwaukee, $342,000, 1 daughter, 4 grandchildren. In September 2024, the dementia reached the point where Helen could no longer live alone. Memory care in Brookfield. Medicaid qualified. The house was exempt during her lifetime. The paperwork said so. Helen passed in October 2025. The home went through probate. Wisconsin Medicaid filed a claim for $289,417. After the claim, realtor fees, and closing costs, Linda received $31,204 from the sale of the house her mother lived in for 41 years. Ronald was 77, retired Tampa Fire Department lieutenant, paid off home in suburban Tampa, Florida, $398,000, 2 sons, 6 grandchildren. In the fall of 2021, Ronald's elder law attorney drafted a ladybird deed, an enhanced life estate deed that transfers property at death completely outside of probate. Total cost, $612. Ronald signed it on a Wednesday afternoon. In March 2025, Ronald entered memory care. Medicaid paid for 18 months. Ronald passed in September 2026. The ladybird deed transferred the home outside of probate. Florida's MERP program had no legal pathway. Ronald's sons received $398,000, free and clear. Same Medicaid, same home, same grief. The difference, a $612 document signed 4 years before the crisis arrived. Let me show you the scale of what is happening right now, nationally in 2026, while most families are completely unaware. According to KFF's 2025 Long-Term Care Report, approximately 1.4 million Americans currently receive Medicaid-funded nursing home care, Average annual expenditure, $87,600. Average stay before death, 2.3 years. That is $201,480 per person sitting in the recovery pipeline. That last number, sit with it. $201,480. Not a penalty, not a fine, not a mistake. A legally mandated reimbursement claim filed by every state in the country under federal law. Every state, no exceptions, no opting out, no case where the state looks at the family and decides to let it go. This is the probate ambush, and it is not an accident. It is policy. The Medicaid Estate Recovery Program was made mandatory in 1993 under OBRA. Every state that accepts federal Medicaid matching funds, every state, is legally required to operate a recovery program. No exceptions for middle-class families. No exceptions for modest homes. No exceptions for grandchildren counting on an inheritance. Here is the mechanical detail most families never understand until too late. Probate is a public court proceeding, records visible to anyone online. State Medicaid agencies operate automated systems that scrape probate court dockets daily, searching for deceased Medicaid recipients. The moment a probate opens with Helen's name on it, the algorithm flags it. A claim is generated and filed within the creditor notice period, typically 30 to 60 days after death. Not your broker, not your banker, not the social worker who said the house was safe. None of them warned you that a government algorithm was waiting for your parents' name to appear in the county court database. That is not bad luck. That is a system designed to recover money, and it is designed to recover it from the exact moment the family is least prepared to fight it, the weeks immediately following a death. Now here's the tax clock. And I want you to listen to this with both ears. If you are 62 and your parents own a home, you have a 5 to 10 year planning window. The moves are cheap, legal, and fast right now. At 68, the window is narrowing. If your parent has entered a nursing facility, the look-back clock has started. Some moves remain, many do not. At 73, if your parent has been on Medicaid more than 12 months, the probate ambush is already loaded. The only question is whether probate can still be avoided. At the moment of death, the window is closed. The claim is filed within 60 days. There is nothing left to plan. The window is closing. I spent 11 years inside estate planning and elder law. I've watched a retired postal worker in suburban Indianapolis receive a $247,391 recovery claim on a home worth $289,000. He walked away with $19,483 after 36 years of his mother's mortgage payments. I've watched families in Ohio, Indiana, and Wisconsin sell homes that should have been inheritances to repay a program the social worker called free. A board-certified elder law attorney charges $3,500 to $5,000 to explain what comes next. You're getting it in 9 minutes. Part 1. What probate is and why it's MERPs. Front door probate is the court-supervised process through which a deceased person's assets are identified, debts are paid, and remaining property is distributed to heirs. If you die owning a home in your name alone, no joint owner with survivorship rights, no trust, no beneficiary designation, that home must pass through probate. There is no way around it unless a specific legal structure was established before death to route the asset outside the probate system. During probate, the estate is legally required to notify all known creditors and publish public notice for unknown creditors. Medicaid agencies are creditors. They file claims just as a credit card company or hospital would file a claim, except they have federal law requiring them to do so. Here is what most families do not understand. The Medicaid agency does not need to prove the home will be sold. They file the claim against the estate. The claim attaches to whatever assets exist. If the estate has no cash, which is common because the person spent down to $2,000 to qualify for Medicaid in the first place, then the house is the only asset available to satisfy the claim. The personal representative of the estate, usually the eldest child or named executor, now carries a fiduciary duty. They must satisfy valid creditor claims before distributing anything to heirs. Failure to do so exposes them to personal liability. Linda could not legally give herself or her children $1 from Helen's estate until the Medicaid claim was addressed. That is the probate ambush. The state walks in through the front door of the court system, the same court system the family is relying on to handle the estate, and it takes what it is legally owed before anyone else gets anything. Let me show you the machinery behind the letter Linda received. Every state maintains a deathmatch database. When a Medicaid recipient dies, their name and social security number are matched against SSA death records, automated in 2026. Many states contract this to private firms paid on percentage recovered, financially incentivized to file every possible claim. The claim equals total Medicaid expenditure from age 55 onward. According to Medicaid.gov's 2026 data, the average MERP claim against an estate with a home is $203,847. In New York, Massachusetts, and California, claims exceeding $400,000 are common. Filed within the creditor notification period, 4 months in Wisconsin, 3 in Ohio, 2 in Texas. The timing varies. The obligation does not. Stop. Before I get to the TEFRA lien, the version that files against the home while your parent is still alive, I need to ask you something directly. Is your parent currently on Medicaid in a nursing home or memory care facility? And is the family home still in their name? Drop your answer in the comments. Your state, your parents' situation right now. I read every comment personally in the first 48 hours. Your situation might become the next video. Your comment becomes someone else's warning. Part 3. TEFRA liens, the silent ambush while your parent is still alive. Here is where the probate ambush gets its second mechanism, and this one is even less known. In approximately 1/3 of states in 2026, the Medicaid agency doesn't wait for the recipient to die. They file what's called a TEFRA lien, named after the Tax Equity and Fiscal Responsibility Act of 1982, against the home while the recipient is still living in the facility. The TEFRA lien attaches to the title. Visible in a title search, growing every month silently, while the family assumes the house is simply waiting for them. Most families learn about it when they try to sell, refinance, or when the probate attorney orders a title search after death. States using TEFRA liens aggressively in 2026, Oregon, Washington, Massachusetts. States that largely don't, Florida, Texas, New York. This is not bad luck, this is by design. The state you live in determines not just whether you face MERP, you will everywhere, but whether recovery begins before or after your parent's death. Wait, I need to pause here, because what I'm about to show you, the 3 legal structures that root the home completely outside of probate, is the part most estate planning attorneys do not explain in a first meeting. I'm going to be direct with you. A standard revocable living trust, a standard will, and standard probate planning do not protect against MERP. They are probate avoidance tools. MERP works through probate. If you root the home outside of probate using the right structures, MERP's pathway is eliminated. That is what Ronald's attorney knew that Helen's family never found out. We've covered what probate is, how the automated MERP claim system works, and what TEFRA liens do before death. But here is what most people watching right now are missing. Probate is not inevitable. It is the default. And the default is what MERP depends on. Change the default. Legally, inexpensively in advance, and the probate ambush has no door to walk through. Stay with me. This is exactly what Ronald did. Here are the 3 moves Ronald made, and that you can make starting today. Step 1, the Ladybird Deed. Available right now in 5 states. If you live in Florida, Texas, Michigan, Vermont, or West Virginia, this is your first call tomorrow morning. A Ladybird Deed lets you retain full ownership and control of your home during your lifetime. Sell it, mortgage it, renovate it. No children's permission required. The deed does not trigger the look-back period. At death, The property passes to your named beneficiaries entirely outside of probate. No court, no creditor notice period, no window for MERP to file. Ronald's Ladybird deed cost $612 and required one afternoon. When he passed in September 2026, the home transferred to his sons before any probate case was opened. Florida MERP filed no claim. There was no estate to file against. Cost $400 to $700. Time 1 to 2 weeks. If you are in one of these 5 states, this is the most important $612 decision in your family's financial life. Step 2. The Medicaid Asset Protection Trust for all other states. Outside the 5 Ladybird deed states, the most effective MERP protection is an irrevocable Medicaid Asset Protection Trust. The MAPT transfers the home into an irrevocable trust. The grantor retains the right to live there for life. At death, property passes to named beneficiaries outside of probate and outside of MERP's reach in states with standard probate-based recovery. Critical requirement: the MAPT must be established at least 60 months before the Medicaid application. The look-back clock applies to trust transfers. The lead time is not optional. It is the entire protection. Cost $3,500 to $6,000. Time 3 to 6 weeks. If your parent is 74 or older without a MAPT, the window is narrowing. Every month without it is a month of look-back exposure that cannot be recovered. Step 3. The small estate affidavit plus beneficiary deed in expanded states. In states with expanded estate recovery, Ohio, Indiana, Arkansas, standard probate avoidance is not enough. The state can pursue assets that pass outside of probate through joint tenancy, TOD deeds, and certain trusts. In these states, the MAPT must be structured to survive expanded recovery analysis. This requires a board-certified elder law attorney in your state, not a general estate planner, not an online document service. Ask specifically, does your state's expanded recovery statute capture assets held in an irrevocable MAPT? If the attorney hesitates, find a different attorney. According to the National Academy of Elder Law Attorneys, families who established a Medicaid-compliant probate avoidance structure before a care event retained an average of $287,000 more than families who did not. The difference between Linda's $31,204 and Ronald's $398,000 was one $612 document signed 4 years in advance. The families who protect their homes from the probate ambush are not lucky. They are not wealthy. They are not plugged into some network of insider attorneys that most families never access. They just knew what you now know. Linda didn't know. The social worker told her the house was safe. True, as far as it went. Nobody finished the sentence. Not the social worker. Not the nursing home coordinator. Not your broker. Not your banker. Nobody. Ronald knew. His attorney finished the sentence in 2021, 4 years before the crisis arrived, and showed him a $612 solution to a $398,000 problem. You just closed that gap. Today is your day one. If what I showed you today matched your family's situation, if your parent is on Medicaid right now, or if you own a paid-off home and nobody has ever explained what happens to it when you die, hit the like button right now. That click puts this in front of the next Linda before she's standing in that kitchen. Comment below your state, your parent's situation, and whether anyone has ever told you the full sentence, not just the house is safe, but what happens to the house after death. I read every comment personally in the first 48 hours. Your situation might become the next video. Your comment becomes someone else's warning. I've put together the free Senior Shield Probate Ambush Protection Checklist. 4 specific steps organized by your state and your parent's age, including the exact questions to ask an elder law attorney in your first meeting. It's in the description below. Download it before you close this tab. It took Ronald one afternoon to act on. It may save your family $398,000. Subscribe and flip the bell. Next week, the widow's tax cliff, the bracket ambush that doubles the IRS bill for the surviving spouse in their very first filing year after a loss. Most advisors have watched this happen. Almost none of them warn you before it does. You will be warned.